Welcome back to SCOTUS Oral Arguments and Opinions. In this episode, we'll discuss the June 27, 2025 Supreme Court opinion in the case called FCC versus Consumers Research, case number 24-109. This case was consolidated with SHLB Coalition versus Consumers Research, case number 24-422. Please note that this summary is read by an automated voice. In this case, the Supreme Court ruled 6-3 that the Federal Communications Commission's Universal Service Contribution Scheme does not violate the Constitution's non-delegation doctrine. The case centered on whether Congress impermissibly delegated its taxing power to the FCC by allowing the agency to determine how much telecommunications carriers must contribute to fund universal service programs without setting specific rates or caps. Justice Kagan's majority opinion held that Section 254's requirement that contributions be sufficient to support universal service, combined with statutory criteria defining eligible services and beneficiaries, provides an intelligible principle that adequately constrains agency discretion. The decision upholds a system that currently taxes carriers at nearly 37% of their interstate telecommunications revenue, costs that are ultimately passed on to consumers. In this episode, we'll examine Justice Kagan's majority opinion defending the intelligible principle test against Justice Gorsuch's dissent, which argued that Congress has never before permitted an executive agency to set domestic tax rates without legislative specification. Then we'll analyze the significant concerns raised in Justice Kavanaugh's concurrence about delegations to independent agencies, and Justice Jackson's skepticism toward the private non-delegation doctrine. Finally, we'll consider the implications for future delegation challenges, particularly given the Court's notable refusal to defend certain provisions of the Universal Service Statute and the growing judicial tensions over agency independence. The questions presented in this case are: 1. Whether Congress violated the non-delegation doctrine by authorizing the Commission to determine, within the limits set forth in Section 254, the amount that providers must contribute to the fund. 2. Whether the Commission violated the non-delegation doctrine by using the administrator's financial projections in computing universal service contribution rates. 3. Whether the combination of Congress's conferral of authority on the Commission and the Commission's delegation of administrative responsibilities to the administrator violates the non-delegation doctrine. Justice Kagan delivered the opinion of the Court in which Chief Justice Roberts and Justices Sotomayor, Kavanaugh, Barrett, and Jackson joined. Justice Kavanaugh and Justice Jackson filed concurring opinions. Justice Gorsuch filed a dissenting opinion in which Justices Thomas and Alito joined.
Justice Kagan's majority opinion. The Communications Act of 1934 established the Federal Communications Commission, FCC or Commission, and instructed it to make available to all the people of the United States reliable communication services at reasonable charges. That objective is today known as universal service. The Universal Service Project arose from the concern that pure market mechanisms would leave some population segments, such as the poor and those in rural areas, without access to needed communication services. Under the 1934 Act, the FCC pursued universal service primarily through implicit subsidies, using its rate regulation authority to lower costs for some consumers at the expense of others. In 1996, Congress amended the Act and created a new framework for achieving universal service. Section 254 of the amended statute requires every carrier providing interstate telecommunications services to contribute to a fund known as the Universal Service Fund. The FCC must use the money in the fund to pay for universal service subsidy programs. The statute designates the beneficiaries of universal service subsidies: low-income consumers, those in rural areas, schools and libraries, and rural hospitals. And it provides detailed guidance regarding the communication services to which those beneficiaries should have access. In deciding what services to subsidize, the FCC shall consider the extent to which a service is essential to education, public health, or public safety, and has been subscribed to by a substantial majority of residential customers. So too, the Commission must evaluate whether a service can be made available at an affordable rate. Section 254 also sets forth principles on which the FCC shall base its universal service policies. Among other things, those principles direct that all consumers, including low-income consumers and those in rural areas, should have access to quality services at affordable prices. The FCC also may add other principles found both consistent with the Act and necessary and appropriate for the protection of the public interest, convenience, and necessity. To calculate how much carriers must contribute to the fund, the FCC has devised a formula known as the contribution factor. That factor is a fraction, expressed as a percentage, whose numerator is the fund's projected quarterly expenses, the subsidy payments it will make plus overhead, and whose denominator is contributing carriers' total projected quarterly revenue. A carrier must pay into the fund an amount equal to its own projected revenue multiplied by the contribution factor. The FCC has appointed the Universal Service Administrative Company, a private not-for-profit corporation, as the fund's permanent administrator. Section 54.701A. The administrator manages the fund's day-to-day operations and also plays a role in producing the financial projections that end up determining the contribution factor. Each quarter, the administrator projects the fund's expenses, adds up revenue estimates it receives from carriers, and submits those figures to the Commission for approval and eventual use in calculating the contribution factor. In December 2021, the FCC set a 25.2% contribution factor for the first quarter of 2022. Consumers Research petitioned for review in the Fifth Circuit, contending that the Universal Service Contribution Scheme violates the non-delegation doctrine. The en banc court granted the petition, replacing a panel decision to the contrary. In the full Fifth Circuit's view, the combination of Congress's delegation to the FCC and the FCC's subdelegation to the administrator violated the Constitution, even if neither delegation did so independently. Held, the Universal Service Contribution Scheme does not violate the non-delegation doctrine. A. Article 1 of the Constitution provides that all legislative powers herein granted shall be vested in a Congress of the United States. Accompanying that assignment of power to Congress is a bar on its further delegation. At the same time, this court has recognized that Congress may seek assistance from its coordinate branches and vest discretion in executive agencies to implement the laws it has enacted. To distinguish between the permissible and the impermissible in this sphere, this court asks whether Congress has set out an intelligible principle to guide what it has given the agency to do. Under that test, Congress must make clear both the general policy the agency must pursue and the boundaries of its delegated authority. BB. Although the intelligible principle standard has long guided this court's non-delegation doctrine, Consumers Research insists that a different test applies here. According to Consumers Research, universal service contributions are taxes, and tax statutes, Consumers Research argues, must satisfy a special non-delegation rule. For those statutes, Congress must set a definite or objective limit on how much money an agency can collect, a numeric cap, a fixed tax rate, or the equivalent. Section 254 contains no such limit, so, in Consumers Research's view, it is unconstitutional. The court rejects that argument. To begin with, precedent forecloses it. In both J.W. Hampton and Skinner v. Mid-America Pipeline Company, the court declined requests to create a special non-delegation rule for revenue-raising legislation. The test Consumers Research proposes also would throw a host of federal statutes into doubt, as Congress has often empowered agencies to raise revenue without specifying a numeric cap or tax rate. Consumers Research responds that those other statutes can be distinguished as imposing fees rather than taxes and thus be exempted from its numeric limit requirement. But Skinner made clear that whether a charge is a tax or a fee is irrelevant to the non-delegation inquiry. Finally, the Consumers Research position produces absurd results, divorced from any reasonable understanding of constitutional values. Under its view, a revenue-raising statute containing non-numeric qualitative standards can never pass muster, no matter how tight the constraints they impose. But a revenue-raising statute with a numeric limit will always pass muster, even if it effectively leaves an agency with boundless power. In precluding the former and approving the latter, the consumer's research approach does nothing to vindicate the non-delegation doctrine or the separation of powers. C. Under the usual intelligible principle test, the Universal Service Contribution Scheme clears the non-delegation bar. Section 254 directs the FCC to collect contributions that are sufficient to support universal service programs. The word sufficient sets both a floor and a ceiling. The FCC cannot raise less than what is adequate or necessary to finance its universal service programs, but it also cannot raise more than that amount, and the sufficiency ceiling imposes a meaningful limit on the Commission because Section 254 also provides appropriate guidance about the nature and content of universal service. The statute makes clear whom the program is intended to serve: those in rural and other high-cost areas, with a special nod to rural hospitals, low-income consumers, and schools and libraries. And it also defines the services those beneficiaries should receive. In order for the FCC to subsidize a service, the service must be subscribed to by a substantial majority of residential customers, available at affordable rates, and essential to education, public health, or safety. Those conditions, each alone and together, provide the FCC with determinate standards for operating the Universal Service Program. Consumers Research contends that the Act gives the FCC boundless authority, but the provisions it points to show nothing of the kind. It first argues that the Commission need not actually adhere to each of the criteria Section 254 uses to define universal service. Properly understood, however, those criteria are separately mandatory. Next, Consumers Research highlights Section 254, C1's description of universal service as an evolving level of telecommunications services that the Commission shall establish periodically in light of advances in technology. That provision, it says, enables the FCC to redefine universal service as it sees fit. But the permission Congress gave the FCC to fund different services over time does not strip the statute of standards and constraints. The Commission still may fund only essential, widely used, and affordable services for the benefit of only designated recipients. Finally, Consumers Research maintains that the statutory provision enabling the FCC to articulate additional principles to guide its universal service policies allows the agency to rewrite its own authority. But that is not so, because Section 254b7 requires the added principles to be consistent with the rest of the statute, so they cannot change the statute's other principles, much less its conditions on what subsidies can go toward and who can receive them. D. Consumers Research separately claims that the FCC has impermissibly delegated authority to the administrator to set the contribution factor. In making this argument, Consumers Research invokes what is commonly called the private non-delegation doctrine. In Carter v. Carter Coal Company, this court struck down a statute authorizing certain coal producers to set rules for the rest of the industry, finding the delegation improper because it was made to private persons whose interests are often adverse to the interests of others. But a counterpart case approved a statute permitting private actors to make recommendations to a government agency for approval, disapproval, or modification. That arrangement was valid because the private parties functioned subordinately to the agency and were subject to its authority and surveillance. Under those precedents, the Commission's use of the administrator is permissible. The administrator is broadly subordinate to the Commission. The Commission appoints the administrator's board of directors, approves its budget, and requires the administrator to act consistent with its rules and directives. And the Commission's authority and oversight over the administrator extend to determining the contribution factor. Working within FCC rules, the administrator produces the initial projections of carrier revenues and fund expenses that feed into the contribution factor. The administrator then reports its figures to the Commission, which reviews, and if needed, revises, the projections before approving them and publishing the contribution factor. The Commission then has 14 days to make additional changes before the factor is deemed approved by the Commission, EBD. So although the Administrator makes recommendations, the Commission is throughout the final authority. E. The Court also rejects the basis of the decision below, that the combination of Congress's grant of authority to the FCC and the FCC's reliance on the Administrator violates the Constitution, even if neither one does so alone. The Fifth Circuit founded that theory on Free Enterprise Fund versus Public Company Accounting Oversight Board, where this court struck down a statute because it gave an executive officer 2 layers of protection from the president's removal authority. Even granting that each layer of protection was alone permissible, the court thought the combination was too much. According to the Fifth Circuit, similar reasoning applied here. Even if Congress lawfully conferred discretion on the Commission, and the Commission lawfully sought assistance from the Administrator, the combination was impermissible. But the court's logic does not work. In Free Enterprise Fund, the 2 layers of for-cause protection operated on a single axis, with the one exacerbating the other. That is not the case here. A law violates the traditional non-delegation doctrine when it authorizes an agency to legislate, and a law violates the private non-delegation doctrine when it allows non-governmental entities to govern. Those doctrines do not operate on the same axis. So a measure implicating, but not violating, one does not compound a measure implicating, but not violating the other in a way that pushes the combination over a constitutional line, reversed and remanded.
Justice Kavanaugh's concurring opinion. This case presents a narrow but important non-delegation question. May Congress authorize the Federal Communications Commission to determine the monetary amount sufficient to fund certain telecommunications services, which in turn is the amount that telecommunications carriers must contribute to the Universal Service Fund? Applying the long-standing intelligible principle test set forth by this court's precedents, the court today upholds a congressional delegation to the FCC. I join the court's opinion and write separately to make 2 points. First, I will briefly outline what I understand to be the background and rationale behind the intelligible principle test that the court has long used to assess congressional delegations of authority to the executive branch. Second, I will explain why congressional delegations to independent agencies, as distinct from delegations to the president and executive agencies, raise substantial questions under Article 2 of the Constitution. From the start in 1789, Congress has delegated to the president the power to exercise discretion and policymaking authority when implementing legislation. Those delegations have been a regular feature of American government ever since. The court has generally permitted such delegations. As to the text of the Constitution, the court has rejected arguments that the president impermissibly wields legislative power when exercising discretion or policymaking authority delegated by Congress. Instead, the court has reasoned that the president ordinarily exercises executive power under Article 2 when implementing legislation, even if he employs discretion or policymaking authority when doing so, and even if the executive branch issues legally binding regulations. The history of congressional delegations and the court's understanding of Article 2's text correspond to what the court has described as the practicalities of legislative and executive action. Congress delegates, at least in part, because it must adapt legislation to complex conditions involving a host of details with which the national legislature cannot deal directly. And the Constitution has never been regarded as denying to Congress the necessary resources of flexibility and practicality. Although the court has ruled that congressional delegations to the president are permissible as a matter of constitutional text and history, the court has not said that anything goes with respect to those delegations. Congress may not give the president or an executive agency a blank check to legislate. So members of Congress could not, even if they wished, vote all power to the president, and adjourn sine die. Congress likewise cannot merely assign the president to take over the legislative role as to a particular subject matter. Rather, the court has said any congressional grant of authority must supply some guidance to the president. Otherwise, the president would no longer be exercising executive power when implementing legislation. To address that question of degree and ensure that the president is exercising executive power when implementing legislation, the court in 1928 adopted the intelligible principle test. If Congress shall lay down by legislative act an intelligible principle to which the person or body authorized to act is directed to conform, such legislative action is not a forbidden delegation of legislative power. Rather, when implementing legislation that contains an intelligible principle, the president is exercising executive power. For 97 years, the intelligible principle test set forth in J.W. Hampton has formed the foundation of the court's non-delegation doctrine. Under the test, Congress may lay down the general policy and standards that animate the law, leaving the agency to refine those standards, fill in the blanks, or apply the standards to particular cases. To be clear, the intelligible principle test is not toothless, but it does operate in a way that respects the president's Article 2 authority to execute the laws, that is, to exercise discretion and policy-making authority within the limits set by Congress and without undue judicial interference. I see no need in this case to try to spell out a definitive guide for applying the intelligible principle test, and it would probably not be possible to do so anyway. It is important, however, to emphasize 3 points. First, under the intelligible principle test, the degree of agency discretion that is acceptable varies according to the scope of the power congressionally conferred. Congressional delegations of authority to the president must be judged according to common sense and the inherent necessities of the governmental coordination. Second, many of the broader structural concerns about expansive delegations have been substantially mitigated by this court's recent case law in related areas, in particular the court's rejection of so-called Chevron deference, and D, the court's application of the major questions canon of statutory interpretation. Third, in the national security and foreign policy realms, the non-delegation doctrine, whatever its scope with respect to domestic legislation, appropriately has played an even more limited role in light of the president's constitutional responsibilities and independent Article 2 authority. Congressional delegations to independent agencies, as distinct from delegations to the president and executive agencies, raise substantial Article 2 issues. Critiques of broad congressional delegations sometimes focus on officials described as unaccountable bureaucrats, but that label does not squarely fit delegations to executive agencies. In those circumstances, the president and his subordinate executive officials maintain control over the executive actions undertaken pursuant to a delegation, and the president is elected by and accountable to all the American people. Rather, the problems with delegations to unaccountable officials primarily arise from delegations to independent agencies. Independent agencies are headed by officers who are not removable at will by the president and who thus operate largely independent of presidential supervision and direction. Those independent agency heads are not elected by the people and are not accountable to the people for their policy decisions. This case involves a congressional delegation of authority to the FCC. The FCC has commonly been viewed as an independent agency headed by 5 commissioners. But at oral argument in this case, the government correctly pointed out that the FCC formally is not an independent agency because the FCC does not have statutory for-cause removal protections. In other words, no statutory text restricts the president's authority to remove FCC commissioners at will. For those reasons, I tend to agree with the government that the FCC, in light of the statutory text, should not be considered an independent agency. If the FCC were an independent agency, however, then a serious Article 2 delegation problem would arise, in my view. When Congress delegates authority to the president or an executive agency, the exercise of that delegated authority is controlled by the president, who was elected by and is accountable to the people. But when Congress delegates authority to an independent agency, no democratically elected official is accountable. Such a system of disembodied independent agencies with enormous power over the American people and American economy operates in substantial tension with the principle of democratic accountability incorporated into the Constitution's text and structure, as well as historical practice and foundational Article 2 precedents. There are at least two possible solutions to the problem caused by congressional delegations of authority to independent agencies. One is to overrule or significantly narrow Humphrey's executor so that the heads of all or most independent agencies are removable at will by the president and thus supervised and directed by the president. A second option would be to apply a more stringent version of the non-delegation doctrine to delegations to independent agencies. Congressional delegations of policy-making authority to independent agencies raise significant Article 2 issues. In an appropriate case, this court should address that problem. As the court explains, Congress has delegated authority to the FCC with respect to the Universal Service Fund in accordance with the long-standing intelligible principle test. If the FCC were an independent agency, however, the question would be more difficult. Because that issue is not presented in this case, I join the court's opinion in full.
Justice Jackson's concurring opinion. Respondents in this case have challenged the Federal Communications Commission's Universal Service Program under both the traditional non-delegation doctrine and the private non-delegation doctrine. The court properly rejects both challenges today, and I join the court's opinion in full. I write separately to express my skepticism that the private non-delegation doctrine, which purports to bar the government from delegating authority to private actors, is a viable and independent doctrine in the first place. Nothing in the text of the Constitution appears to support a per se rule barring private delegations, and recent scholarship highlights a similar lack of support for the doctrine in our history and precedents. In today's case, none of the parties addressed these concerns, and the court had no reason to consider them sua sponte because respondents' private non-delegation claim failed on its own terms. But we should tread carefully before entertaining challenges under this theory in the future. When the Constitution's text does not provide a limit to a coordinate branch's power, we should not lightly assume that Article 3 implicitly directs the judiciary to find one.
Justice Gorsuch's dissenting opinion: within the federal government, Congress alone has access to the pockets of the people. The Constitution affords only our elected representatives the power to decide which taxes the government can collect and at what rates. Throughout the nation's history, Congress has almost invariably respected this assignment. As this court observed some decades ago, it would represent a sharp break with our traditions for Congress to abdicate its responsibilities and bestow on a federal agency the taxing power. Today, the court departs from these time-honored rules. When it comes to universal service taxes, the court concludes an executive agency may decide for itself what rates to apply and how much to collect. In upholding that arrangement, the court defies the Constitution's command that Congress may not transfer to another branch powers which are strictly and exclusively legislative. In 47 U.S.C. Section 254, Congress has authorized the Federal Communications Commission, FCC, to subsidize a number of disparate programs under the umbrella of universal service. The FCC selects which programs to pursue and how much they should cost. To fund them, the agency taxes telecommunications companies at a rate it controls. By regulation, those companies are then free to pass the charges along to consumers like you. This case involves a challenge to that scheme. Section 254 describes universal service as an evolving level of telecommunications services that the agency must both preserve and advance. To determine which specific services to fund and at what level, Section 254C1 directs the FCC to consider 4 factors. On top of those 4 factors, the statute supplies 6 further principles in Section 254B. In addition, the FCC may adopt other new principles that it determines to be necessary and appropriate. From this mash of 4 factors and 6, now 8 principles, the FCC must discern which programs it wishes to fund and to what degree, and it falls to the FCC to balance these factors and principles against one another when they conflict. As the FCC has long put it, all 4 criteria enumerated in Section 254C1 must be considered, but not each necessarily met. Over time, the services the agency has funded have evolved considerably. So, for example, in 1996, the FCC debated whether to subsidize touch-tone service, not just old rotary phones. By 2011, the FCC comprehensively reformed and modernized its universal service goals to include expanding access to Internet services nationwide. More recently, the agency has announced that the Universal Service Fund will help put Wi-Fi on school buses. As the scope of the FCC's programs has expanded, so have the taxes the agency collects to fund them. In 1998, universal service disbursements totaled about $2.29 billion. In 2024, that figure swelled to about $8.59 billion, nearly double, adjusted for inflation. To pay for that increase, the contribution factor, or tax rate, has risen too. In 1998, carriers paid less than 4% of their revenue from interstate and international telecommunications. Today, that figure is nearly 37%. Section 254 impermissibly delegates Congress's taxing power to the FCC, and knowing that is enough to know the Fifth Circuit's judgment should be affirmed. Under Section 254, the FCC may compel carriers to contribute money to support what everyone agrees is a government program. That is a quintessential tax, a compulsory contribution to the support of government. Several FCC commissioners, including at least 2 FCC chairmen, have seen it the same way, referring to universal service contributions as taxes. Before us as well, the FCC has said that it is willing to have this court treat universal service contributions as a tax. Taxation ranks among the government's greatest powers. Indeed, it is arguably the federal government's most important authority. As this court has put it, the power to tax is the one great power upon which the whole national fabric is based. Reflecting as much, the Constitution provides that all legislation for raising revenue must originate in the House of Representatives, the only popularly elected chamber at the time of the Constitution's adoption. That context matters. To survive the intelligible principle test, a delegation involving such a significant power must supply more significant limits on an agency's discretion than when Congress confers some lesser authority. What exactly does the intelligible principle test require in this context? Surely history must count for something, and it supplies at least one clear standard. As far as I can tell, and as far as petitioners have informed us, this court has never approved legislation allowing an executive agency to tax domestically unless Congress itself has prescribed the tax rate. Applying that insight here poses petitioners with a serious problem. All agree that Congress has not set the rate at which the FCC may exact contributions. Instead, Section 254 delegates to the FCC the power to determine which services to fund and thus the amount of money to collect. To secure those funds, the agency uses the administrative company to set a contribution factor, i.e., the percentage of its revenues a carrier must pay. That's a tax rate. And remember, that rate has grown from less than 4% of carriers' applicable revenues in 1998 to nearly 37% today, all based on the agency's say-so and without any change to the statute. Nothing in the U.S. reports suggests that an executive agency may exercise that kind of power over taxation. Having failed to identify a single example where this court has approved a tax delegation like this one, petitioners in the court propose a workaround. Yes, they concede. Section 254 imposes no quantitative limits on how much money the FCC can raise. But they contend Congress has provided guidance that amounts to a qualitative cap. To support that claim, petitioners in the court emphasize that Section 254D requires the FCC to collect taxes sufficient to preserve and advance universal service. The word sufficient, they submit, imposes an obligation on the FCC to ensure that the Universal Service Fund is large enough, but not too large, to achieve the statutory goals Congress supplied. Even taken on its own terms, I find that response unpersuasive. Really, the numbers speak for themselves. Recall that in 1998, the FCC disbursed about $2.29 billion. A quarter century later, that figure hit about $8.59 billion. Even adjusting those figures for inflation, the FCC has nearly doubled the amount of tax it collects, far from supplying qualitative directions akin to a numerical cap. Section 254 supplies little more than a blank check. Truth be told, the court does not find its own response entirely persuasive either. It upholds the ability of the FCC to tax and spend for universal service programs under Section 254C1. But recall, Section 254, C3 and H2 also allow the FCC to support advanced and additional services without regard to Section 254C1's factors. And in a remarkable footnote, the court scruples to say those two provisions sufficiently constrain the agency's taxing power. Together with Section 254D, that provision merely tells the FCC to tax carriers in an amount sufficient to preserve and advance universal service. To my eyes, it's hard to see how that direction might be fairly analogized to a numerical cap. The statute, remember, does not say what universal service is, and the phrase bears no established meaning. Of course, the statute proceeds to offer some direction to the agency about what qualifies as universal service, and thus how much it can tax and spend. But even viewed charitably, that guidance can hardly be described as the functional equivalent of a numerical cap. It instructs the FCC to discern the evolving meaning of universal service from the primordial soup of four factors found in Section 254C1, as supplemented by 6 principles discussed in Section 254B1 through 6, as well as whatever further principles 2 and counting the agency chooses to devise under Section 254B7. Many of these factors and principles address competing goods, and any effort to weigh them all can yield no more certainty than asking whether a particular line is longer than a particular rock is heavy. Searching for some way, any way, to support the notion that Section 254C1 contains a qualitative cap on how much the FCC can tax and spend, the court eventually resorts to rewriting the statute. Now it says, the FCC can fund a service only if it meets all of subsection C1's 4 factors. It's a nice theory, but it bears no resemblance to the law Congress adopted. By its terms, Section 254C1 requires the FCC only to consider the extent to which each factor applies. The statute nowhere says each or any of those criteria has to be met before the agency can fund a particular service. In fact, the FCC has long and consistently understood the statute to mean the opposite. All 4 criteria enumerated in Section 254C1 must be considered, but not each necessarily met. So much for the court's renovation of Section 254C1. Now consider the two provisions the court cannot bring itself to defend. Sections 254C3 and H2, recall, permit the FCC to fund additional and advanced services for schools, libraries, and healthcare providers. Even the court is unwilling to say that these provisions impose a qualitative cap, and understandably so. When it comes to deciding what programs to fund under Section 254C3 and Section 254H2, the FCC is unconstrained by any of the subsection C1 factors the court rewrites and leans on so heavily today. Rather than address the constitutionality of the FCC's power to tax and spend for Section 254C3 and Section 254H2 programs, the court dodges the question. Buried in a footnote midway through its opinion, it offers this: we have no occasion to address any non-delegation issues raised by Sections 254C3 and H2, the court says, because while respondents challenged the contribution scheme generally, they did not name those provisions in particular. Though it is unwilling to say aloud that any part of Section 254 fails the intelligible principle test, neither can the court bring itself to bless such a lavish delegation of taxing authority. Today marks the first time in a long time that the court has confronted a statutory delegation and found no way to save it. No one disputes that part of the statute lacks a tax rate or a numerical cap, and rewritten or not, that provision lacks anything approaching a qualitative cap as well. Faced with these difficulties, in the end, petitioners and the court resort to changing the conversation. Now they say, look to other fields. The court has allowed agencies to raise revenue through fees without specifying a numeric cap, or rate. The court has allowed agencies to set just and reasonable rates and to regulate in the public interest. But the court's comparisons disregard its own insight that context matters in applying the intelligible principle test. Those provisions all have something in common. Each describes a fee, and that makes them poor benchmarks for a tax delegation. Fees, by definition, are payments made in compensation for a service provided to, or alternatively, compensation for a cost imposed by the person charged the fee. For that reason, fees carry a built-in intelligible principle. The government cannot collect more money than it needs to offset a real-world cost or benefit. Once we understand fees correctly, the category plainly includes all the government's examples and excludes Section 254 contributions. When carriers pay into the Universal Service Fund, they do not gain any special benefit, nor do Section 254 contributions offset some regulatory cost that carriers impose on the FCC or on society. Instead, Section 254 takes money from some carriers and gives it to others, libraries, schools, and the like. In short, Section 254 creates a classic tax and spend scheme, not a fee. This court has recognized this point many times, including when it comes to phrases like public interest. So, for example, the court has held that phrase may contain enough concrete meaning to survive the intelligible principle test in the context of broadcast licensing, where the government has to allocate a limited spectrum of publicly owned airwaves. But the court has also found the same public interest criterion offers inadequate guidance to the FCC when it comes to raising revenue. The same goes for the phrase just and reasonable. This court has sometimes found that phrase satisfies the intelligible principle test when it comes to setting rates for regulated monopolies like public utilities, a context where it incorporates concepts with a long history at common law. But outside that sphere, the same phrase may amount to little more than an instruction to go forth and do good. When Section 254C1 speaks of universal service, it does not invoke concepts with a long history at common law. To the contrary, everyone agrees that Section 254 ripped apart the old understanding of universal service and cleared the ground for a new one. Notice, too, where trails like this lead. If context could be cast aside, and a phrase like just and reasonable might suffice in every season, nothing would stop Congress from granting agencies limitless legislative power. Congress might delegate to the Secretary of Education the authority to set a just and reasonable tax on university endowments in order to fund universal education, defined, of course, according to 4 factors and 6 or more incommensurable principles. Running out of precedents to work with, the court suggests finally that it would be absurd to ask Congress to provide more guidance than it has. But even assuming that a cap alone might be permissible when it comes to Section 254, the court too readily dismisses its constitutional value. Forcing Congress to supply some cap, any cap, would advance the non-delegation doctrine's purpose of ensuring that the lines of accountability remain clear. The framers divided power among legislative, executive, and judicial branches not out of a desire for formal tidiness, but to ensure ours would indeed be a nation ruled by we the people. In so many other arenas, this court vigorously polices the Constitution's allocation of power. We have refused to tolerate congressional intrusions on powers reserved to the president. We have prohibited the executive from encroaching on power vested in Congress. We have found unconstitutional, too, legislation seeking to confer judicial power on the other branches. Yet there is one exception. When Congress has willingly surrendered its power to the executive branch, this court's responses can only be described as feeble. Always, to be sure, the court dutifully recites the creed that legislative power belongs to the legislative branch and to no other. Too often, though, these professions amount, at most, to faith without works, and the results are not hard to see. Today, the vast majority of the rules that govern our society are not made by Congress, but by presidents or agencies they struggle to superintend. There is another way. The Constitution promises that our elected representatives in Congress, and they alone, will make the laws that bind us. To honor that commitment, historical practice and our cases suggest other guides beyond the intelligible principle test for assessing when Congress has impermissibly ceded legislative power, as I have pointed out before. By employing the modern, enfeebled form of the intelligible principle test, we do the Constitution no favors, and by approving a delegation of Congress's taxing power unprecedented in this court's history, we risk making matters worse yet. Still, there is room for some optimism. The court today cannot bring itself to say that Section 254, C3, and H2 survive even its milquetoast version of the intelligible principle test. The court also refuses to sustain Section 254C1 as enacted, feeling obliged instead to rewrite that provision before upholding it. I can imagine worse outcomes than those small steps toward home, but we can and should do better. Respectfully, I dissent.
All right. Those were the majority concurring and dissenting opinions. Now, let's talk case implications. The Supreme Court's decision in FCC vs. Consumers Research carries significant but carefully circumscribed implications for the non-delegation doctrine's application to federal agencies. The majority's affirmation of the intelligible principle test for revenue-raising statutes, while rejecting calls for heightened scrutiny of tax delegations, suggests continued judicial deference to congressional delegations that provide qualitative guidance rather than numeric limits. However, the court's notable reluctance to address Sections 2, 5, 4, C3, and H2, relegated to a footnote disclaiming any ruling on those provisions, signals potential vulnerability in broader or less constrained delegations. Justice Gorsuch's observation that this marks the first time in a long time that the court has confronted a statutory delegation and found no way to save it suggests the majority may be approaching the outer bounds of permissible delegation, even under the traditionally lenient intelligible principle standard. The concurring opinions reveal important doctrinal tensions that may influence future cases. Justice Kavanaugh's pointed discussion of independent agencies, noting that delegations to such entities raise substantial questions under Article 2, indicates growing skepticism about agencies insulated from presidential control, though his conclusion that the FCC lacks for-cause removal protections avoided that issue here. Justice Jackson's skepticism toward the private non-delegation doctrine could signal future challenges to restrictions on government reliance on private entities. Meanwhile, Justice Gorsuch's dissent, joined by Justices Thomas and Alito, demonstrates continued appetite for more robust non-delegation enforcement, particularly regarding taxation powers. The fractured approach suggests that while broad congressional delegations remain constitutionally viable under current doctrine, the court may be more receptive to challenges involving independent agencies, private delegations, or statutes lacking even the qualitative constraints the majority found sufficient in Section 254(c)(1). Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Up next, Mahmoud versus Taylor. Talk to you soon.